G'day there guys, it's your Aussie hubby Markee, back at it again with another episode of r/legal advice. Now if you love me like I love you, then you know what to do. I want you to tackle that like button like you would tackle any legal contract that comes into your life. Maybe even chuck an Aussie flag down in the comments. With that said, I want you to sit back, relax, chuck a prawn on the barbie, and enjoy the content. Posted by user Advice Needed 911, titled, House We're About to Close on Flooded, Help. Hi, I need some advice here. My spouse and I are supposed to close on a house on Monday, Texas, USA. But now the house has flood damage because the seller hired incompetent people to move his washer and dryer, which caused a massive flood in the house. It damaged flooring in the laundry room, entry, and living room. The seller ripped the baseboards as they were also flood damaged. I should mention that we got a text from our realtor that said, the seller wants to know if he can start taking out the flooring. To which we said no, because we wanted the flooring company we would hire to do that. He did it anyway, and he damaged a tile on the fireplace in the process. Additionally, the seller had an estimate done for the new floors since the flood ruined them, and has only agreed to give us $4,000, but the estimate is for over $5,000. My spouse and I are feeling really stressed about all of this, and we think we should back out because this house is not the same one we put an offer on because of the flood damage. We would never have put an offer on this house in its current condition. Can we back out and still get our earnest money back? Did my time later, chumps, says, yay, you haven't closed. So this is the seller's problem right now. You need to talk to your realtor and find out how they are going to mitigate the damages the move has caused. You should be able to walk away or push back the closing date unless the seller fixes the problems to a reasonable level of satisfaction. This could include pulling back and drying all the carpets, etc. Talk to your realtor. They have your interests in mind. If you really need it, contact the Texas Bar Association for a real estate referral. The realtor does not have our interests in mind. She has been unhelpful and seems to care about nothing but getting the sale. She's honestly terrible. My problem is, I would have never put an offer on this house in this condition, and I'm not comfortable signing until I have a licensed and bonded flood inspection report done by the seller, which I do not have right now. If the realtor won't push the date back, I am backing out and not signing, but I don't want to lose my earnest money. Then don't close on the house, don't sign anything. Talk to that agent's manager if you need to. Here's a Texas bylaws thing. You can check this and see if the realtor has any complaints against them as well. The site wouldn't work for me, unfortunately. It says it's having an issue connecting to the database, so I can't check, but that would have been great info to have. If you haven't already, try opening it in a few browsers on a laptop or desktop computer. Some of the texas.gov and related sites still work best in Internet Explorer of all things. Have a consultation with a real property attorney to review the contract. They should be able to tell you exactly what steps to take to get your earnest money back, and the money you spend for a consultation will be worth avoiding any missteps. Then, fire your realtor and get one with your interests in mind. But we're supposed to sign tomorrow. Don't sign! Why would you even be thinking about signing? Right now, the flooding is the seller's problem. As soon as you sign, it becomes 100% yours. You can always postpone the signing until you have time to fire your realtor and consult an attorney. I'm saying I don't have time to get a lawyer. Then make time. She can't physically grab your hand and make you sign. Don't get pushed over by this. Chat with a lawyer ASAP to see what you can do. And if that means you don't sign yet, then let that be their problem. Follow your lawyer's advice. Call several lawyers at 8 a.m. tomorrow morning and find the first willing to give an initial free 15-minute phone consultation. Follow their advice. Robbie Throw says, Source, I'm a licensed realtor. Good news, you've not closed on the property. Nearly all contracts in use these days are developed in consultation and with the approval of the National Association of Realtors. As such, there will be a clause, likely in the inspection area of your contract, saying the house must be delivered in the same or better condition as it was when the contract was agreed on. Please make sure, read and highlight this section on your contract and take it to your realtor's supervising broker. This is the person who is more or less the boss of your realtor, i.e., their license is hung in and held by this office. The house has been damaged. You should be able to be released from the contract. If the broker still refuses, contact the local area board of realtors and take this to the board president. You should also contact an attorney who specializes in real estate law. You can also lodge a complaint with the NAR, the National Association of Realtors, and their state equivalent. I found it. It's in the possession clause. Says exactly that. Seller gives buyer the property in present condition. It's not in the condition we signed for in April, so we appear to have a condition to walk and get our earnest money back. But where we're at, we think that if we get all the documentation of the repairs the seller did on the flooring and get a flood inspection report done, we would be comfortable signing. But all that is not going to happen by tomorrow, which is why we need an extension. Fantastic. I would contact the agent's broker immediately, explain the situation, and ask them to send you an extension to sign. If they refuse them, you're well within your rights to walk. She says she needs a couple hours, so I guess she's working on that. Or, knowing her, she's busy trying to find a way to say no and try to force us into signing. She has been the worst. That's unfortunate. I hate this side of realty. It's one of the reasons people see many of us as nothing more than used car salesmen. Keep putting pressure on her and CC her broker on any emails. Also, it's not a bad idea to screenshot your texts. Best of luck. Definitely, and thank you. There's a good reason I only text and email her. I do not trust her at all. She has been so dishonest, and she even yelled at me when she was frustrated that I was mad at the seller wouldn't give us more money to repair the floors. But I can't fire her at this point in the process. Yes, you do have power. Talk to the broker, her boss, as the other poster has instructed you to, and deal with them here on out. Algebra Lover, and I said that intentionally wrong, says, make sure you get an independent inspector in there to be certain repairs were completed. You need someone with a moisture meter to check the flooring, drywall, etc. It should be someone with experience in water damage remediation. A friend was a seller in a situation like yours. In their case, they had to move out, and a pipe burst 2 days before selling. Their insurance company covered the repairs. Update. I sincerely appreciate everyone's help and input. I've never bought a house before, so this flooding incident has stressed me out quite a lot. I found the clause in our contract that states that the house must remain in present condition at the time of signing, so I feel confident that we could back out if necessary and retain our earnest money. Additionally, our realtor, after days of us asking, just now sent us the repair report from Stanley Steamer, and it looks really good. It was about $2,500 of repair and drying work done over 3 days. So we're now feeling confident that things were taken care of correctly, and once we get the new floors in, it will be okay. I truly appreciate everyone's help. Still hate our realtor. Oh my god, I would too. Posted by user Chuchumon, titled, Rental agreement signed and deposit sent for 2-bedroom apartment. Just found out one of the bedrooms is locked by the owners. Hello Reddit. I'm moving to a new city, Alberta, next month, and will be renting a condo. 2 weeks ago, I signed the lease for a condo management company without going in person or sending a video of the place, which was a big mistake because of COVID-19. Today, I finally got the chance to video chat with the current tenant and found out that one of the bedrooms is locked by the owners and not available for use. The original ad stated 2 bedrooms, and I have emails with the condo management company that shows the ad. However, I realize now that the number of bedrooms is not stated anywhere on the lease agreement. Only the address of the suite is on there. Does this mean I have legal rights to the entire place? I have reached out to the person at the condo management company, and she says she's looking into it, and it was her first time hearing this. But I feel like they'll just chalk it up to inaccurate advertisement. What are my options? Any advice would be much appreciated. I'm moving in a month, so hopefully there's enough time to sort this out. Thanks in advance. Duck Diver says, talk to the management company about either having the room made available or getting out of your lease. Too much hassle to deal with that. The lease, by giving the address and presumably by its language, allows you access to the entire property. But busting down the door and then moving all their stuff out is going to be a massive problem and the wrong move. What a hassle. Just talk to the management company and say if that room isn't available for use, you will not take possession of the unit and will take action for breach. The easiest remedy will be cancelling the lease. It's unlikely the management company even knows of this. So is this a 3-bedroom apartment and you'll only have access to 2 of them? Or was it advertised as 2 bedrooms but 1 is not available? I'm not a lawyer, but I've read here that in Canada, it's a lot easier to evict a roommate than a tenant. The owner/landlord could be reserving a bedroom for themselves because of this. But if you need 2 bedrooms and the place functionally has only 1, it seems to me grounds to void the lease. It's a 2-bedroom apartment and only 1 is available. Would I still get my deposit though if I void the lease? Not a lawyer. If they don't provide the whole apartment, they are the ones breaking the lease. Unless the lease says otherwise, renting a unit at an address means the whole unit. Call the PTDRS on Tuesday and ask. It's a service offered by the provincial government to mediate disagreements between landlords and tenants. In my opinion, you entered into the apartment expecting a 2-bedroom apartment, meaning you expect to have 2 bedrooms. The owner only intends for 1 bedroom to be available. Clearly, there's no meeting of the minds and the contract should be voided. You are entitled to your deposit back. You may have to go through RTDRS to get them to return the deposit. Update: the condo manager got back to me. Apparently, the owners are overseas and won't be able to open the locked room. The unit was intended to only have 1 bedroom by the owners, but the condo manager didn't know until today. They have offered to give me my deposit back. Thanks everyone. Posted by user Lollipop. Titled, "Can my landlord make us pay $67 fee to pay rent online?" California, Los Angeles area. We have lived in this apartment complex going on the 4th year, and it was recently sold to another company. We received a letter stating that we are to pay online from this month on, which is wonderful as it's way easier than dropping it off. However, that is the only way we are allowed to pay, and we are just now finding out that they're charging a $67 fee to do so. As you can imagine, rent is already astronomical. Is this legal? Can they actually force us to pay this way and pay online? Can we make them give us an address so we can mail it or drop it off? We've been trying to contact the management company for 3 days. First because the website doesn't even work, and then because of the fee, and they are not answering. Anything we can do? Apologies if this is a stupid question. Thanks, LA. On all of those systems that I have used, if you pay with a card, it charges you a ridiculous fee. If you add your bank account and pay that way, it is free. Have you checked that? Hey, you were totally right. Thank you. Doing it by e-check is free, but the debt card is $67. We've been on the phone with the company for like 30 minutes, lol. Major shout out to you. Otherwise, we would have been losing that extra $67 every month. I owe you a round of beers, thank you so much. You might consider creating a separate bank account to which you transfer the rent every month from your main account. That way, the landlord doesn't have access to all your money, just that 1 bit of rent each month. With the direct link to your account, you're giving them very easy access to it. It's not unheard of for them to try to take the rent money out on the due date without you knowing until the money is gone. We are going to open a different account this week just for this. Thanks so much. While I'm not worried about them taking the rent out on the due date, I definitely do not want them to have access to the entire checking account. We do plan to buy soon, and when we leave, I don't want them deciding they can just take out whatever they'd like during the moving out process. I've never paid rent online before, so this is totally new. Thank you very much for your insight. If you are under an existing lease and it does not allow for charges like this, then it comes out of your rent. So if your rent is $1,200, you take out the service charge from that. While OP figured it out, in addition, California requires a fee-free form of payment. I didn't know that. Got any links? Just for the future reference for my friends that might be in a similar situation. Thank you so much. Most Google results return COVID-related, but this has stuff about how they must allow an option other than cash/electronic. And if you guys can find that one, I wish you the best of luck. Great article, and it addresses exactly this issue. Thank you. They also say that we did have a lease for the first year, and then the last few years have been technically month to month. And it's already been addressed, but they put an update anyway. Update, it's free if you're using an actual checking account and not the card associated with the checking account. Thanks to that user, you saved us a grip of money. Thank you. Posted by user, got a bumble my dude. Titled, Child Custody / ICWA. Can I prevent the adoption of my infant nephew and have him placed in my custody? Hello all. I would like to know if it would be possible to obtain custody of my deceased sister's infant child and prevent his adoption through the Indian Child Welfare Act. For clarification, my husband, family, and I are active members of the Kiowa tribe in Oklahoma and live within the tribal jurisdiction. We regularly participate in events and have a member involved in government. 2 years ago, my 14-year-old sister ran away from home, and earlier this month, her boyfriend informed us that she had passed away from COVID-related pneumonia. He also told us that he was putting her 1-year-old baby boy up for adoption. From the way he referred to my nephew, it sounded as though he was not the biological father of the baby. My husband, our extended families, and I would like to raise our nephew within our culture after 2 centuries of our native children being stolen and sold to white families or put into foster care. And from what I understand, the Indian Child Welfare Act is supposed to protect our right to retain our children. However, we may not be able to afford a lawyer for a drawn-out custody battle, and I would like some opinions on whether it is likely we could win custody if ICWA could help, and if certain information could push the odds in our favor. Thank you. Edits. Our tribe is federally recognized, and my nephew qualifies as a member since our parents are full native, 1/4 blood quota. Edit number 2. We took everyone's advice and called my tribe's ICW program earlier this morning to give a brief rundown of our situation, and we have a meeting planned for next Wednesday. We've also reached out to the boyfriend for further clarification. My sister had been living with a couple in Oregon for nearly a year, so it seems likely the baby was born there. But when I asked about custody, he became quite nasty and said that my nephew's adoption was already paid for. Usually Sunny says, you and your tribe would have to legally intervene in the case and get in touch with social services. Start with your tribal government. Just to supplement this, under ICWA, the tribe has the right to intervene at any time. Much case law interprets this as even after the trial is over. The tribe has enormous discretion in these cases. The same is not true for OP, as he does not qualify under that ICWA provision. This doesn't mean he cannot intervene, just that ICWA doesn't give as much to the individuals as to tribes. OP says, someone below mentioned that chain of contacts may depend on whether my nephew's been put up for private adoption or taken by the state. How would this affect the case? ICWA is a federal law that applies to all Indian children, regardless of whether they are in custody of a private adoption agency or of CPS and DFPS. Just to clarify, ICWA applies in specific foster care, termination, or adoption proceedings. ICWA does not always apply in all custody cases involving an Indian child. Yes, you're right. When I said all, I just meant that the applicability of ICWA isn't connected to particular agencies, for example, state versus private, but I'm glad you chimed in to clarify. The Sheba says, private and dependency cases are treated the same under ICWA. The tribe can intervene at any time, and I believe if the child is eligible for enrollment or is an enrolled member of your tribe, the tribe would have to be notified about the proceedings. If the tribe has not been notified, it might invalidate anything they've done legally thus far. This is what happens in dependency cases at the very least. Hopefully your tribe will be willing to claim jurisdiction, which they can do even if the case's jurisdiction is in another state. Bingo, you hit the head on the nail. The only thing I would supplement is that not only dependency cases will trigger ICWA protections. Cases like the current one also will require compliance with ICWA. Fuego Pants says, assuming the boyfriend truthfully discloses the child's tribal affiliation, the tribe will be notified of the adoption. You need to talk to your tribal representative. Let them know you want the child. The tribe has the right to intervene in the case at any time as long as the tribe agrees the child is an Indian child under the definition laid out under ICWA. Is your tribe federally recognized? Because if not, ICWA doesn't apply. Update 25th of May. I met with our ICW representative in Anadarko, and he says that we can prepare a case. We won't be able to get birth records for a few weeks, since all record lobbies near us are closed due to COVID-19. Also, those who asked private messaged me for names and locations to help locate my nephew in Oregon. Thank you, but it would be irresponsible for me to give out that information, especially the little information we have is tenuous at best. I've been trying to reach the boyfriend for more information about the potential adoption and my nephew's location for the last few days, but he has yet to reply since our last conversation above. I'm not sure what to do if he doesn't reply. I'll try and keep this post updated, but we were warned that we may have a couple long months ahead. Thank you everyone for your help. And our next one I've already covered before, but there is an update to it now. By user Parking Spot Help 1192, titled, Condo Board is telling me as of June 5th, the parking spot I own will be converted into a handicapped spot, but there are no other parking spots available. Is this legal? This started back in December. I own a parking spot that is right next to the 3 existing handicapped spots in my condo building. I have paperwork that says I am the owner of the parking spot A5. Me and my wife inherited this condo from my mother. In December, apparently a new tenant moved in, who requires a handicapped parking spot. However, our building already does not have enough parking for everyone. For roughly 100 units, we have maybe 50 spots tops. Back then, I was asked by the condo board if I was willing to give up my spot for these people who needed a handicapped spot. I was okay with it until they explained there were no other available spots. Instead, they wanted me to sign over my parking spot in exchange for nothing. Apparently in 2022, when the parking garage expansion will take place, I will be the first on that list to receive one of the new spots. Until then, apparently I'm shit out of luck, since this is downtown Toronto, where parking is extremely limited. At that point, both me and my wife refused to sign anything. In February, the condo board yet again tried to get me to sign paperwork, and I refused. They offered to pay for a spot for me roughly 10 blocks away at another building. I told the condo board yet again I am not interested. They have tried to guilt both me and my wife numerous times about this. The tenant who needs the spot has approached me and my wife several times about how we are making her life a living hell. In April, the condo board during the board meeting thing put a vote asking for people to vote for the conversion of parking spots A5 through to A7 to be converted into 2 handicapped parking spots. The motion passed. However, neither me or the people in A6/A7 are budging so far. Today, I received a letter stating that as of June 5th, 2020, I will no longer be the owner of parking spot A5. I didn't sign any paperwork and have told our condo board to pee off. My questions are, is this legal? Can the condo board take away our parking spot that we own? And do we have any sort of legal alternatives? Just to clarify, I am not really trying to be a dick. However, these new people who moved in bought the unit fully knowing they were not buying a parking spot. Instead, my understanding is they expect the apartment building is to provide them a handicapped spot free of charge. Location, Toronto, Ontario. Update. Condo board is telling me as of June 5th, the parking spot I own will be converted into a handicapped spot, but there are no other parking spots available. Is this legal? Thank you for all the advice. We ended up talking to a lawyer on Tuesday, and we paid him a small amount to write a nicely worded letter indicating that our condo board had no right to do what they are doing. The condo board has more or less agreed that they are in the wrong. Yeah, screw them. And will be pursuing other alternatives to create handicapped parking for this new owner. Today, the owner who wants the spot came to my door, telling me that I need to move my car because as of today, it belonged to her. I explained to her what the condo board told me and she got very upset. For now, I am not going to move my car because I think she could be more of an issue than my condo board. To answer a few questions, I did offer the condo board an option to buy my spot for a stupidly high price of $200,000 and a guaranteed spot when they increase parking space. They are not interested. I do in fact own this parking spot. It is owned by me and deeded to me. There is no street parking and stopping in front of our building. Handicapped spots are actually owned and managed by the building. The issue came to heads when the people who bought the condo had a verbal promise that there was available handicapped parking. However, not long after making that promise, another tenant needed a handicapped parking spot due to him being stuck in a wheelchair, so the spot ended up going to him. The actual owner, who was complaining about this, actually owns a non-handicapped spot. However, they refused to trade it because they have 2 vehicles. Their other vehicle is one of those specialized minivans for wheelchairs. What are they doing complaining then? Jesus. Finally, the owner, who has been making all of this fuss, has been trying to take the condo board to court over this. Anyways, thank you LegalAdvice for your help. Why does the owner have 2 vehicles? Get rid of one. It's Ontario, Toronto. You can't just strong-arm someone out of a spot and then force them to take one 10 blocks away. Dear Lord, that is an ungodly amount of walking for one spot, and you already own your own. What an asshole. Actually, screw them. I don't care if they have a specialized minivan. That's all you need. What's wrong with people? G'day there guys, Outro Markee here. Just wanted to say thank you so much for watching today's episode. I hope you really enjoyed it. Hope you enjoyed it as much as I enjoyed making it. Now with that said, we have some special mentions. Everyone that signed up for my Patreon, everyone that's a channel member, you guys all know who you are. I'm going to start putting you on screen in the near future. Sorry, I'm very lazy, but I do love each and every one of you, and you all know that. If you want to join, there is links down in the description below. If you want to be a channel member, there's a join button next to subscribe. It helps me out immensely. Also, I have a second channel that does memes. It's called Markee 2. It should be on screen here now. If you like memes and you want to laugh with me, it's some not so politically correct content all the time. Hope you enjoy it. Click on the screen, subscribe, and enjoy the memes. That's all I have for today, and I'll see you in the next episode. Bye.